We bring in Attorney Ralph Sarmiento, International Law Professor, also the Vice Chancellor for Administration of the University of St. La Salle College of Law. Attorney, welcome to Starcon and thank you for joining us this afternoon.
Maraming salamat po and good afternoon.
Good afternoon, sir. Sir, what we're trying to divine here, we've been trying to divine for the past so many days, is what exactly should we watch out for in terms of, proving or disproving the connections, di ba? The alleged crime and the alleged perpetrator. Kasi when you say substantial grounds, that sounds so generic. What exactly are we looking for?
And we know already from the prosecution's filings that they are accusing Duterte of a so-called common plan to carry out the EJ case. But specifically, what will substantial grounds look like here?
First po, let me run you through yung mga different thresholds with respect to the International Criminal Court. No? First, for purposes of warrant of arrest, yung language po ng Rome Statute is reasonable grounds to believe. That is for purposes of the issuance of a warrant of arrest. And then for purposes of confirmation of hearing, so mas mataas po na threshold, so that is now substantial grounds to believe. And then for purposes, so nandun po yun sa Article 61 ng Rome Statute and then sa Article 66 ng Rome Statute, for purposes of conviction, yung siyempre po, yun yung beyond reasonable doubt na threshold. So yung substantial grounds to believe, yung importante po doon is that may sufficient evidence to establish na may substantial grounds to believe. Now, we have to take note po na there will be no actual presentation of witnesses na mangyayari. Normally, that is the procedure. Normally, what will be presented only are documentary evidence and minsan po just summary evidence. Kasi po yung mga actual witnesses will be presented during the trial proper after or assuming na there will be confirmation of the charges against the former President Rodrigo Duterte.
You mean, sir, a formal submission of evidence, documentary evidence. In other words, babasahin ito ng pre-trial chamber in the 60 days following the start of the COC.
Opo. They will study that, and then if they are convinced that the evidence is sufficient to bring him to trial, dun na po magkakaano confirmation of the charges.
But sir, in which case, will we have an idea in the next 4 days kung malusog ba yung ebidensya ng prosecution? Kasi nga, if it's all documentary evidence, they will have to produce
technically, we will be able to make an assessment. Although, of course, yung assessment natin, mga personal opinion and evaluation lang yun. Ultimately, it will be the court which will evaluate kung talagang sufficient bang evidence. And of course, that's for the purpose of not wasting the time and effort of the court na you will bring a person to actual trial and then hindi naman pala sufficient yung evidence against him. So kaya nga, if you notice under Article 61 of the Rome Statute, may tatlong options or may tatlong possibility after the conduct of the confirmation of charges hearing. So number one, pwedeng i-confirm ng court yung charges. And when we say confirm the charges, hindi po requirement na lahat ng charges need to be confirmed. Hindi po all for one for all yon. So kahit na po isa lang sa mga charges ang confirmed, then it will go to trial. And then for the charges that are not confirmed, either may option in prosecution of either amending the charges or pwede rin po they can conduct further investigation and then present additional evidence, but that will require another confirmation if there will be new charges that will be alleged or filed by the prosecution team. And then yung second possibility is if the court does not, based on its appreciation, there is no sufficient evidence, then it will decline to confirm the charges. And then yung third possibility, it will just adjourn the hearing, adjourn the confirmation of charges hearing, and then either recommend for further investigation or submission of additional evidence, or if the court believes na the evidence proves a different crime, not the one actually charged, then they can actually recommend or call for the amendment of the charges.
Attorney Sarmiento, of course we know that Duterte has waived his right to appear today, despite being ruled, fit to do so. I've asked other lawyers this, but I'm also interested in your opinion. Is there any significance there? And does the defense gain anything by keeping him away from the judges at this point?
The purpose of the presence of the accused is actually for the benefit of the accused, and that is to protect, because that's one of the rights of the accused, yung presence niya during trial. And of course, for practicality's sake, if you are present physically during the confirmation of charges, your legal counsel will be able to coordinate with you, consult you immediately, and then there can be an immediate feedback and decision on these matters. So if you are not around, so that will require your legal counsel will have to make a decision without you, and then either consult you during the break or by the evening after yung adjournment on a day-to-day basis, and then ganun yun. Pero so technically wala po siyang masyadong that significant na effect on the continuation of the proceedings. And besides, it's the right at this particular stage of the confirmation of charges hearing, it is the right of the defense or the accused in this particular case to be present or not. But it will be different in the actual trial. Kasi po in the actual trial, it is mandatory. Yung presence of the accused is now mandatory. So sabi po ng Rome Statute under Article 63 na the accused shall be present during the proceedings. Although of course in exceptional circumstances, pwede pa rin po yung the court may allow like yung presence through video link, but that is usually decided by the court on a case-to-case basis depending on the circumstances of the particular case.
Prof, walang arraignment, no? I mean, there's no such thing as a pleading, whether you're asked if you're pleading innocent or guilty.
The way we understand it sa domestic proceedings po, no, wala po dun sa...
Well, so there are three possible outcomes after this week. If the judges decide to the case has enough substantial grounds to proceed to trial, can the defense appeal that as well? Because remember, even this confirmation of charges hearing was already delayed because they appealed it. Dapat, if I recall, this was supposed to have been held in September of last year, and then the defense appealed it, which is how we got to this point. They appealed it based on medical grounds, saying that Duterte was unfit to stand trial. So yeah, if they decide yes, it has substantial grounds to proceed to trial, can the defense appeal it again?
No, normally po hindi po appealable yun because the normal course after that is now to convene the pretrial chamber, which will now hear the evidence and witnesses for that particular charges confirmed by the pretrial chamber.
So no, there's no more appeals process after this. Straight into trial na tayo.
Opo, normal.
With what you know about with this case and how the prosecution has prepared, how would they determine? So we know, for example, that there are 47 cases that they are using as a representative for this three crimes against humanity charges, right? But we also know that at least 500 other victims have applied to become part of the case file. What do you know about how they would divide up all those cases in the confirmation of charges hearing part versus the actual trial part?
I think the actual trial part, no, kasi divided naman po ito sa different counts, no. So by time frame po ito, like for example, yung first count, yung when he was as mayor of Davao, and then at the beginning of the presidency, and then during the clear period towards the end of the last 2 years before our withdrawal from the International Criminal Court from the Rome Statute. So magiging orderly naman po. Although of course I can just imagine yung logistics and everything. It will also be messy, and this will also be very, very difficult on the part of the prosecution, especially in establishing all these charges, especially with the threshold of beyond reasonable doubt, which is required as the international standard for purposes of conviction. And we must understand this is not a very simple case because this is not just the ordinary murder under domestic law na alam po natin under the revised penal code na murder, na killing under certain circumstances. Yung murder po as a crime against humanity, so it has a different, it has different elements which are not in the ordinary crime of murder, because the prosecution will have to establish the contextual element of widespread and systematic attack against a civilian population. So even establishing the multiplicity of killings, even if they are able to establish that, they will have to establish that those killings were done as part of a widespread and systematic attack against a civilian population with knowledge of the attack. So medyo yun po yun actually yung medyo difficult and challenge on the part of the prosecution.
But sir, in previous cases, how were they able to make that link or establish that connection between what was happening on the ground and the possibility that it was policy initiated from the top?
Yeah. Or
Normally po they usually look into the parang holistic na view, no? They will have to look into the actions undertaken by the government, the way they implemented their policies. They can also look into the mga statements, even mga media interviews of their president, yung mga police departments nila, and then titingnan nila, may pattern ba? Is there a pattern? Is this being done as a matter of policy? So parang ganun. So you have to establish that. Kasi po kung if you are not able to establish that, then all these killings will be parang considered na parang baka isolated to. Baka these are not actually being done as a matter of policy on the part of the government or on the part of the accused. So they will have, parang yun yung challenge on the part of the prosecution.
But sir, I suppose another challenge is the other way around. I mean, in the last 6 years of the Duterte, in the 6 years of the Duterte administration, he was prone to giving outrageous statements, very, very public statements about killing people, killing addicts. And these were quite outrageous in the normal sense. So on one hand, you might have that na pwedeng gamiting bala against him. On the other hand, mali naman siguro sabihin ng kabila na the fact that it's so outrageous, maybe it also means that it was hyperbole or exaggeration.
Pwede po. Yung po actually yung doon, yung debatable na issue doon, because they will have to look into that. Kasi on the part of the defense, they will have to say na yun, either joke lang po yun, no? But they will say that on the part of the former president, they might probably say na he was also very careful na parang may caveat, but you only do this, parang may proviso na you only do this in either in case of self-defense or when your life is placed in danger, para maganon. Although tingnan na lang po natin how the evidence will go, and on my part I'm also excited to see how these things will play during the confirmation of charges hearing.
So much color, di ba?
so much color. There's so much unknown at this point that we're waiting to see how it plays out during the actual confirmation of charges hearing. But sir, what do you make of the fact that the family is sending 6 Filipino lawyers there, or have sent 6 Filipino lawyers there, led by, of course, former ES Salvador Medialdea and former presidential lawyer Salvador Panelo. I mean, what can they add to this case, as far as the defense is concerned?
Well, I would suppose that I think Kaufman had already studied this case thoroughly, but of course, yung presence of the Filipino lawyers who are from the ground, they will be able to give the real context to the situation and then give proper assistance as to the understanding of the defense, yung context of the defense on yung theory ng defense that they will be putting out against the prosecution.
So they could gain something by the fact that there are Filipino lawyers there who lived through that time and can defend Duterte, is what you're saying.
Well, in a way po, they might be able to help, siguro.
We've also had one other lawyer tell us that they think the defense's strategy here could be to attack the evidence, not the innocence, not necessarily prove the innocence of the man, Duterte in this case. The goal being, this is more of a tactical thing now, the goal being to poke enough holes in the evidence to show that there's not reasonable grounds to believe that it was a common plan, as the prosecution called it, What do you think? Could that work?
Well, technically naman po kasi on the part of the defense, yung threshold po dito is that the obligation to establish the sufficiency of the evidence is actually on the prosecution. So yung hindi po, there will be no, parang hindi pa po obligation on the part of the defense to prove the innocence of the former President Duterte. That will have to be done during the trial if the charges are confirmed. So insofar as the confirmation of charges hearing are concerned, yung pinaka focus po ng proceedings will be the sufficiency of the evidence on the part of the prosecution. If they are sufficient enough to establish sufficient grounds to believe na the crimes had been committed by the former president. So yung focus po doon will be the prosecution evidence. So naturally po yung focus of the defense will be to find holes, to find inconsistencies, to find weaknesses on the part of the prosecution's evidence.
Sounds like that's one of the recourses available to them. We'll leave that there for now, but we'll call you back in, Attorney, after the confirmation of charges hearing. Then we can unpack it together once more. But thanks so much for your time today,
Thanks, sir.
for talking to us. International
Anytime.
Law Professor,
Thank you very much.
Attorney Ralph Sarmiento.